It is a case from Allen County. It's number 126-339 entitled N&B Enterprises, Inc. versus Winona English et al. We have Mr. Keith Brock here for the appellants and Mr. Robert E. Johnson for the appellee. Mr. Johnson, I'm not sure if you're sitting at the your desk or you seem further away, but I guess both counsel are ready to proceed.
I'm in my conference room. Can you guys hear me okay?
Now that you're up full screen, I can see you just fine. So that was my fault.
Okay.
So we will start the hearing with Mr. Brock, who represents the appellants in this case. And Mr. Brock, you have 15 minutes for your argument. Do you wish to reserve any time for rebuttal?
Yes, please. I'd like to reserve 4 minutes for rebuttal.
That is granted, and you may proceed.
Thank you, Your Honor. So this case is essentially a lease termination case. The habendum clause in the lease provided that the lease would remain valid for so long as oil or gas is produced in paying quantities. And in this case, we had alleged that the lease ceased producing in paying quantities and therefore terminated. This case is a little unique in that so many of the elements are agreed upon. In this case, we agreed upon the accounting period to be used. We agreed upon the revenue that applied to that. We also agreed upon all of the expenses that were incurred by the plaintiff. The only thing that was in dispute is the categorization of those expenses as either direct operating expenses or sunk cost, initial development expenses. And so that's really the fundamental issue that we're here on today. In our brief, we've raised 4 issues. I'm going to focus on the first 2 and leave the last 2 to stand on the briefs. If there's any questions about those, I'll answer them, but I feel like they're adequately covered in the brief. So on the paying quantities issue, I believe that the district court's decision, ultimate decision that the lease did not cease producing in paying quantities, that decision was reached as a result of 2 fundamental errors. And the first is that the district court believed that we were alleging that expenses should be imputed to the plaintiff that were not actually incurred. That isn't accurate. The plaintiff introduced its profit and loss statement, and so we're relying on those expenses actually incurred by the plaintiff. We're just disagreeing with the plaintiff as to which of those meets the legal definition as a direct operating expense. So we're not asking that expenses be imputed. The second thing that the district court did was it believed that it was bound to basically accept the plaintiff's categorization of those expenses as either direct operating expenses or they labeled them as indirect expenses. The law would distinguish between direct operating and capital expenditures. And we allege that that was an error because essentially the law sets forth what constitutes a direct operating expense. And so applying the facts to that law in order to decide which of those meets that legal definition is a question of law that the district court should have made as opposed to just taking plaintiff's word for it. In addition, the standard that the plaintiff used to argue which expenses were direct operating expenses or not is completely contrary to Kansas law. The plaintiff testified that only expenses which incur on the lease premises constitute direct operating expenses. That is not the legal standard in Kansas. The legal standard in Kansas is that if these expenses are ordinary and reoccurring, then they're direct operating expenses. If they're extraordinary or part of initial development expenses, i.e. capital expenditures, then they're not counted. And so even though the plaintiff applied the incorrect legal standard, the district court still accepted their categorization of those 2 types of expenses. And that's the real issue that we're here about today.
I just want to clarify. So it would be your position that all operating expenses that are not sunk costs are direct expenses.
The standard, so there's some dispute as to what could be considered company overhead
Right.
in the law. I don't know that it gets into the fringes of that aspect of it, but in this particular case, I don't think that we're not asking for any, say, like second level foreman charges to be added. We're not asking for any office expenses to be added. All of the expenses that we're requesting are expenses incurred in the field in direct operations. So I guess
So
I'm
let me
saying-
ask you this, on Form 14, for example, there's a line for legal expenses. Or is it your contention that that's a direct expense?
So for purposes of this case, we're arguing that the court doesn't even need to go there because the main items of expenses that will get us to where we need to be are chemicals that are used to remove moisture from the gas to make it marketable. The contract labor, which is the daily wages paid to the employees in the field operating the systems on the ground. The gas compression expense, which is the cost to operate the gas compressor to move the gas to the market and
Okay.
increase. Yeah, go ahead. I'm sorry.
So I want to be clear though, because there was testimony as to those expenses about why they're not attributable to this lease. Or why a small portion is attributable, right? For example, the compression isn't necessary because it's free flowing.
So the error there comes just in the difference between the nature of oil and gas. In most of the court's case law, they deal with oil leases. And with oil leases, the gas is sold at the lease, and that's where the expenses incur. With gas, you have to take the expense number at the same place in the system as you take the revenue number. And so, for example, in this case, that gas free flowed to the surface of the lease, but there was no one willing or able to buy that gas at the lease. It was worth nothing because the moisture hadn't been removed. It wasn't suitable to be sold. And so it didn't become suitable to be sold until a much later point in the system. But the court excluded all of the costs necessary to get the gas to that point in time where it could be sold.
How is that not a fact determination that the court made though, not a legal determination?
Could you say the question one more time? It kind of clicked right as you asked it. I'm sorry.
Sorry, how is that not a fact determination from the district court? You know, whether it was direct or not direct, because it doesn't seem like you're arguing for overhead.
No.
So if you're not arguing for overhead, then it seems like not a legal question you're addressing.
So the legal question is whether it meets the definition of a direct operating expense, ordinary and recurring expense. In the context of gas, the law does analyze what a transportation charge is, what a marketing expense is. And we argue that these expenses clearly fall within the definition of those as they're written in Kansas law.
Okay, so there is labor costs attributable to the lease at issue already, correct?
Attributable to the leases?
Right, the court calculated in labor costs.
No, the court did not consider any of the labor expense as part of its paying quantities analysis. And that's kind of the crux of our argument is that you have a full-time employee out there who's monitoring for leaks, who's making this system operate, and the district court included $0 of that expense in its analysis.
All right, maybe I'm misunderstanding Exhibit 14. Continue, I'll double check.
And the same would be true for the chemicals. The chemicals are necessary to remove the moisture. The district court included $0 of that expense in its analysis. The gas compression, the plaintiff testified that you could not move gas to the city and actually sell it unless you compressed it. The district court included $0 of that expense. Repairs and maintenance of the equipment. You can see on the profit and loss statement that these expenses are incurred year after year. We had a 5-year accounting period. The expenses are consistent through that entire 5-year period. but yet the district court included $0 of those expenses. The only, go ahead, I'm sorry.
I'm sorry for interrupting, but please correct me, but my understanding of your position was that, I mean, first of all, that those costs were included, but my understanding of the briefing was that even if those costs were included at a percentage, at the percentage of what that lease, the percentage of the whole of what that lease produced, that it still would have been a profitable lease.
No, so
It was your 1/23rd. It was you proposing that those costs be attributed at that 1/23rd amount rather than per MCF. And I'm sorry if I'm mispronouncing MCF, but
yeah, so the district court was correct. They found under the Wrestler v. Colt decision that the expenses had to be allocated 1/23rd, an equal percentage to each lease.
Oh, I want to, only two of them.
Yeah.
Right? Only the G&L, only the liability insurance and the license. That's my understanding.
So those are the expenses that were incurred, not only attributable to these leases. So like the labor in the field where he's checking for leaks from all leases, those would be the same type of expenses as what the district court's looking at, where they allocated them 1/23rd. So the district court got that part right. It just ignored these other expenses that we're talking about. The reason that the district court got it right is if you allocate it on a per MCF basis, it allows me to hold any leases as long as I have one really profitable one. So I can take a lease on someone's property, and as long as I have another really good lease, I could potentially hold theirs forever, even though theirs could never be operated profitably.
I understand that argument,
Yep.
but the 1/23rd also has a fault, right?
Say it one more time. I'm sorry.
The dividing by 23, prorating that way, also has a similar fault in the other direction, right?
And
And so in Exhibit 14, it's your contention that the district court's holding is that we should do 1/23rd for all direct expenses. Is that your contention?
they held that you should do 1/23rd of all expenses that were not directly attributable to this lease.
All expenses that.
So some of the expenses, like the charts, they have no benefit to any other lease at all. And so for those, you don't need to allocate them. But for the rest, you have to allocate those 1/23rd. Even if the court wanted to allocate them on a per well basis, the reason we argued that they should be allocated on a per lease basis is because that actually benefited the plaintiff. If you allocate on a per well basis, the result is that they're even more unprofitable than they are right now. So it really doesn't matter to me if we did it on a per well or per lease basis, it loses money. When you look at plaintiff's system, they have 3 leases that are very profitable. They're using that to hold 20 other leases that are not. Ours is one of those 20 leases. So my client doesn't get hardly any royalty from it. They're not allowed to use gas in their home because they can't produce it enough to do it, but yet they're being held simply because plaintiff has 3 really good leases. That's directly contrary to the Court of Appeals decision of Wrestler v. Colt. Each lease has to stand on its own. It's a separate independent contract. And the habendum clause of one lease cannot be modified simply because that same operator procured another lease. If they had unitized or pooled them, they could do that, but they haven't done that in this case.
Okay, if I look at Exhibit 14, the second page, I think it's the second page. It's the one with more stuff on it. Okay, admittedly, this is quite difficult to read. I did zoom in on it on my computer. So all of these expenses that have numbers here to the right. Do you see that there for the English lease?
Yes. Hmm.
Is it your contention that these are all correct categories for which should be counted as expenses for the lease?
For purposes of this appeal, I've picked out 4: chemicals, contract labor, gas compression, repairs and maintenance.
I see
The
contract labor on here, calculate.
where do you see pumpers labor?
I see contract labor.
Yeah, that's the one I'm referring to, contract. So the evidence was that was the money paid to the what you would call the pumper. Typically, the only field employee that plaintiff had, that's the amount of money paid to them.
Okay, and so you think this is the correct amount of money?
To clarify, so those are the 4 categories.
Right.
The amount that they have labeled as English lease, they've allocated those on an MCF basis.
Okay.
That
So-
part's not correct. So,
So
but
you're
the
saying that
total,
these 4 categories that you are objecting to, you think all should be bumped up to the 123rd?
yes, 123rd. If the court wanted to divide them by the number of wells in the system, I'd be fine with that too. Either way produces the same result.
And your contention is that you think the district court said they should be done by 123rd.
Correct.
I apologize for taking your time. For that.
No,
Please continue.
Yeah, no, thank you.
Yeah, and that's fine. And you've gone way over your allotted time, which is fine because of the questions. But at this point, you're going into your 4 minutes of rebuttal.
Yeah, and unless there are any other questions, I'd like to save the 4 minutes for rebuttal. Thank you.
All right, Mr. Johnson, you have 15 minutes to argue for the appellee.
Good afternoon, may it please the court, respected counsel. I would advise the court that Chase Vaughn, who's an associate here at my office, is also in the conference room. I hope that's acceptable. Thank you
Yes.
thank you for the opportunity to orally argue this to the court. Mr. Brock and I tried this case for 2 days here in Allen County, and I agree that the main crux of the appeal is probably surrounding the paying quantities issue. I think it's important to point out this is a very unique lease and set of leases. All the case law that we have in Kansas, and it's been cited by Mr. Brock, or our office deals with mainly single lease oil wells, which are entirely different than the case at hand. I know you all have a copy of the transcript, and the only testimony at the trial that explained how these leases work as opposed to coal methane or for oil leases was presented by my client. Mr. Brock did attempt to get an expert qualified. If you review the transcript, as I'm sure you have, that was very rigorous objections and arguments to the court, and the court found that his expert, Mr. Frick, was not qualified and did not admit him as an expert. I think that's important because the only testimony that was given to the court was by the plaintiff, Mark Burris, who owns and operates N&B, the plaintiff. Basically, all of these 23 leases and 86 wells that produce gas are free flowing. That means that there are no lift costs. There's really no cost involved on the lease site. Exhibit 14 is probably the most important exhibit, as evidenced by the briefs and the questions that have been asked, and that is a document we produced in discovery and admitted to court, which was not objected to. by the defendant and admitted by Judge Kreitz. The four categories that Mr. Brock points out, the chemicals, labor, gas compressor, repairs and maintenance, I'm not going to read our brief to the court. However, Mr. Burris was asked a lot of questions regarding that and whether this lease required those expenses compared to the other leases. And his answer was no. I think it's also important to point out that Mr. Burris's history and operation of gas leases and oil wells is well defined within his testimony, and that he did testify upon inquiry that the English lease in and of itself, he could operate that and it would operate under paying quantities. He could make a profit on that lease by itself. I think the questioning dealt with whether he could and what he would need to do that. And I know your honors have read the briefs, and that's within the brief.
Okay, so on this exhibit, I see an amount attributable to gas compression, I think, for the English lease.
Yes, I think that's under gas compressor, maybe.
Okay. And is that, I want to verify that's one of the expenses that's on appeal that we're talking about, yes?
I believe Mr. Brock said the four issues on the expenses were the chemicals, the contract labor, the gas compressor expenses, and repairs and maintenance, I believe.
But on the first page of Exhibit 14, there is no contract labor, gas compression. Those items are not included on the English lease income and direct operating expenses, the first page of Exhibit 14, correct?
That's correct, Your Honor. I could explain that if you'd like.
Please.
I believe the testimony was that the first page of Plaintiff's Exhibit 14 are what my client calls the direct expenses, which would be the general liability, the licensures, the gas meter, gas tax, and property tax, which are expenses that are completely 100% attributable to the English lease itself, just like the other leases. Then on the second page, that's when the breakdown of the pro rata share of those expenses are attributable. I think we need to remember, or I need to remember and point out to the court, the English lease only makes 0.5% of the total production.
Right, and you don't need to point that out. We definitely know that. So for the larger side, the second side, if we include everything there, it's your contention that the lease is still profitable.
Yes.
If we include every expense that Mr. Brock wants us to include under the MCF.
Yes.
Okay. The other side is what your client says are the direct expenses. So your client says gas compressor is not a direct expense, and labor, apparently there's zero labor involved with this lease. No one has to do anything in order for this lease to make gas or to make money, ever.
I think the testimony was that he probably spends 150 minutes a year.
Okay, so not nothing, but not much.
So yeah, two and a half hours a year.
So so it's your contention that even if we include everything Mr. Brock wants to include, if we do it under MCF, still profitable.
I think the second page of Exhibit 14 would show that, and it would actually be more profitable because there's more expenses that are allocated on 14 page 2 than what Mr. Brock is contesting.
Right. Okay. It's just whether or not those should be done MCF versus pro rata, right?
basically, that's Mr. Brock believes that they should be 1/23rd, and we believe, based on the unrefuted testimony and the court's 8-page, single space decision, that that's how they, the trier of fact found it to be. These, I don't want to belabor the point, but these aren't oil leases, and I think Mr. Brock's trying to treat them like oil leases.
Okay, and is it your contention then that in determining what is a direct expense, the court would need to, that would be a question of fact different for every natural gas case or lease, actually?
I think it would be on leases like this that are so unique with very little cost to get the gas to market. I think it is a question of fact, and not to dwell on it, but there is no case law that we could find that deals with these type of leases in Kansas.
Yeah, you're making history. Okay, that's my only, I think I'm done with the questions, so go
Well,
ahead.
we hope we're not making history. Okay, so are there any other questions on that, Your Honors? Okay. The rest of the briefing of the issues, I think, can pretty much stand on their own. I do think that it's important to point out the fact that the defendant had no expert, really had no other evidence other than Miss English. We believe the lease was very clear, not ambiguous as to the principal dwelling on that issue. We didn't appeal the decision on the money judgment, so that's fine.
I'm sorry, Mr. Johnson, I do have one other question. How do you address the contention that using the MCF disproportionately impacts smaller leases when a large lease could, absorb that loss, right?
Well, I guess it could, but it goes the other way as well. If you don't do it on that basis, is it fair if you had lease one that made 50% of the production and you had lease 23 that made 0.5%? Is it fair to say lease one only pays a 23rd when they're taking up 50% of the time, capacity, chemicals, and labor? So I think it goes both ways. The law, as I understand it, the objective rule that comes out of these cases on oil leases was to keep an operator from, holding a lease and not making money. This lease makes money.
Well, I mean, the way you've done it, the lease makes money. There's another way to do it where the lease wouldn't.
Possibly,
Really small. I mean, there's no argument. This is like really small.
Yeah, it's a small production. I think this lease was signed in the 90s. Mr. Burris' father started N&B. They only have one consumer. It's all sold to the city of Iola.
Sure. So basically doing it on either way, either pro rata, both ways produce error sometimes.
Well, yeah, certainly nothing's foolproof.
Do you think there could be some of these expenses that should be done 1/23rd and some that should be done MCF?
Well, it seems like that's what the court did, because the court in its decision talked about the uniqueness of the lease and the fact that general liability, insurance, licensures, I think meters, and things like that are directly attributable to the lease, and therefore 1/23rd. And then based on its finding, it spoke very succinctly about the other expenses, and by finding the lease was producing in paying quantities, we have to rely on Plaintiff's Exhibit 14, which hasn't been contradicted by an expert or other evidence by Mr. Brock's client.
Well, we have to rely on it for the actual numbers. We don't have to rely on it for the pro rata decision. That's
Yeah, I mean, it was tried to the court made the finding, I understand the argument, but, you know, if everything's 1/3, it's not fair to most of the leases. Some would benefit, some would not, and, I think the uncontroverted evidence that I would point to is the only evidence that the producer said that if this lease stood by itself, he could produce it in paying quantities and it would make money.
But if, and this may be irrelevant, but if, say the lease was terminated, I mean, does Miss English, can she use her own natural gas? And is that it? Is that the only benefit she gets from it?
Well, she gets royalty payments, she gets free gas for her principal dwelling.
But if the lease is terminated,
She'd still get gas, right?
you'd still get
Yeah,
gas.
if the lease was terminated, then she would be able to use her gas. She would have to install the, you know, the meter and the pipeline and all that. I guess is that what you're asking?
Yeah, I was just, like I said, it may not be relevant to our conversation at all, but I was just curious, if the lease were to terminate, I mean, what is the benefit to Miss English, I guess?
I don't, there really wouldn't be a benefit. Even though she doesn't get a lot of royalties, she wouldn't be getting that at that point.
You have about a minute left if you still have anything.
I think the rest of the briefing speaks to itself. I would like to thank the court for obviously knowing a lot about this case. I appreciate your questions. Always appreciate working with Mr. Brock. He's respected counsel that we do things together and against, and appreciate the opportunity.
All right, thank you, counsel. Mr. Brock, you still have your 4 minutes of rebuttal. You need to turn your sound on.
I apologize. Is that better? Thank you.
Yes.
To answer some of the questions in reverse order, what does Mrs. English get if she terminates the lease? A lease, the landowner's incentive to enter into a lease is to hopefully realize a profit from the production, make money. When a lease does not make money and the lessee continues to hold a blanket lease over the entire property, they basically hold the title to the property captive. And so if my client wants to sell the property, she can't. You know, in areas where there's a lot of urban development, sometimes the lessee gets paid more money to walk away than the landowner gets for selling their land. It's a blanket lease that covers the entire property, so it's a huge burden to it. That's a big part of it. The other part is, you know, my client's you know, an 80-year-old woman. She uses that to heat her home, and she can't heat her home right now. And so that's what started this case, and that's what, I mean, that's still a big driver. I mean, that's why her pipes froze in the middle of the winter, because she couldn't heat her home because of their operations on this property. So that's a big one. The second thing I'd like to address is the allocation. When the expenses are allocated on an MCF basis, all that does is tell us that plaintiff's entire business is profitable, because they're not, it makes no difference what leases they have or what the individual terms of the leases say. As long as their entire business makes money, then their allocation method indicates the leases produce in paying quantities, and that's just not true. Even if the English lease were the only lease out there, they would still have to have an employee checking for leaks every day. They have an employee go out and look at the pressure, is what the testimony was, to determine if there's a leak. So even if they had one lease, he would still have to do that every day. Even if they had one lease, you would still have to have a compressor to increase the pressure from 6 to 11 to be able to sell it. Even if you had one lease, you would still have to have chemicals to remove moisture to get it to a point where the city of Iola would buy it. What's happening, and the importance of taking the revenue and the expenses at the same point in the system. If we use an example of, like, say, water, if there's a water well and it comes out of the ground, that may not be suitable for human consumption. It's not the same as the tap water that runs out of your faucet. Between the period where it comes out of the well and the period where it gets to your faucet, you have employees spending money and time
Mr. Brock,
monitoring.
let's assume we agree with you about that.
Okay.
Let's assume we agree with you that every expense on the second page, some of it should go to the English lease.
Mhm.
Figuring out the proration is the difficult part because both of these systems are bad.
Yeah, and that's why we revert to the Wrestler v. Colt, which basically allocated them on a per lease basis, finding that each lease had to stand on its own. And so, that's why we went that route. To me, there's really three choices. You could go on a per lease basis, a per well basis, or as plaintiff is arguing, on an MCF basis, which that disregards the lease terms in its entirety. So either of those other two methods, I think someone could present testimony to argue as to which would be, a better method. But in our case, we just went with the same method that the Wrestler v. Colt court decided. And that's the same method that the district court agreed with. And so
This is not an abuse of discretion issue then? I mean, if there's three choices and the judge picked one, then no, I mean, couldn't a reasonable person choose any of those three?
I don't think that the allocation method for the expenses, as far as the 123rd, that wasn't cross appealed. It wasn't challenged. The district court decided that, and the plaintiff didn't cross appeal that decision. So I think it's decided by the trial court. It's just which expenses are included and allocated in that method is what we're talking about today. And I know
You have about 1 more minute.
Oh, I do have 1 more minute. Okay. The last issue that I did want to just talk about briefly was, in this case, there were 2 houses receiving free gas from the lease. The district court found that that was a breach of the lease. It's not a large monetary issue, but in this case, the lease does not provide plaintiff with exclusive right to produce. So the terms of the lease are unique, and the district court didn't consider that. Since the lease is a license in a legal sense, it's only exclusive if the language of the lease makes it exclusive, and this one does not. And so we argue that even though they don't have a contractual obligation to provide free gas, our client could take gas from a well that already existed before the lease and continue using it after the lease under the express terms of the lease. The other argument is that because they were doing it for 23 years and plaintiff knew about it, didn't complain about it, and our client purchased new, appliances and such, that waiver, estoppel, latches arguments would apply. And so she didn't breach the lease. But again, that's a small peripheral issue, but I just wanted to mention it with only the 1 minute. But I thank you all very much. And as Bob said, I thank him as well. It's been a pleasant experience working with them.
All right, counsel, we want to thank you again for participating in today's hearing by Zoom. We appreciate that. And we also thank you for your briefs and your arguments. This case is now deemed submitted for decision. We will take it under advisement and get a written opinion out to you and your clients just as soon as we possibly can. And so with that completes this hearing, and it also completes the cases on today's docket. Thank you.
Thank you all.
Thank you, Judge.